This case clearly revolves around two rights in conflict: the right to bear arms and private property rights. What happens when these two rights are in conflict?
You say that there is a constitutional right to carry a gun on private property?
Yes, Justice.
I've never seen that right. I mean, I understand that there is a right to carry a gun on private property with an owner's consent, express or implicit, correct?
The Second
My
Amendment.
question is very simple. Is there a constitutional right to enter private property with a gun without an owner's express or implicit consent? The answer has to be simply no. You can't enter an owner's property without their consent, correct? Express or implicit?
Correct, because that would be a trespass.
I don't know if she realized it, but Justice Sotomayor just opened a crack in Hawaii's case. You cannot enter private property without the owner's consent. The real question of this case is, can Hawaii determine implied consent? There's an implied consent that people can enter private property for legitimate purposes. Without that implied consent, you could not receive deliveries at your door. Girl Scouts cannot sell you cookies, and your neighbor cannot come to ask to borrow a cup of sugar. This implied consent is expanded when someone opens their private property for public access. Think of a retail store, a museum, or a church. Of course, this implied consent can be terminated by the property owner.
But do you agree that all of the business owners and maybe also private property owners in Hawaii could get together and say, we don't want this, and they could not give consent? Let's say the law is flipped. It says it's illegal to enter if you have been denied permission to carry a gun on the property. You agree that all property owners could get together and say, we're denying permission, and they could put such placards up in their window, and then you would still not be able to carry a gun on 97% of the property in Hawaii?
Yes, Justice. Every private property owner has the right to affirmatively put up a sign or otherwise not give permission for people to enter a property with a firearm. The crux of our argument is that Hawaii has flipped that historical default from them having to affirmatively say guns are not allowed here to the current law.
It seems to me the issue isn't the historical default, but the question of implied consent. I'll talk more about this in the section's second class right. Justice Jackson asked Sarah Harris, Principal Deputy Solicitor General of the Department of Justice, about the Second Amendment issue.
Ms. Harris, can we just be a little bit more specific about the Second Amendment right that you say is being infringed here? This is the point that I guess I'm still stuck on, is whether or not in a world in which we all concede, and I think the United States is on board with this, that the Second Amendment yields to the property interests of a private property owner, such that the private property owner gets to consent as to whether or not you can carry a gun on his property. When we're in that world, what Second Amendment right is being infringed when the property owner says no, or when the state says the property owner's consent has to be expressed?
There is a world of difference between the two scenarios Justice Jackson put forth. When a property owner says no, they are exercising their property rights. When the state says your implied consent does not extend to the right to bear arms, they are infringing on the right by treating it as a second-class right.